stuff. I guess the BOE has updated his guidance. He's already came a couple of times on, I think, a Tuesday morning tour, thanks to Donna, and then he came, I think, in the end of February to update us a little bit more. So Ryan, take it away.
Thanks for having me, everybody. Yeah, so we do have some guidance issued by the Board of Equalization. So I'm going to give you a little presentation here. There we go. All right. Thanks for having me back. We're talking about property taxes again. So as everybody hopefully knows, the Board of Equalization is the state agency who is tasked by the California Constitution to issue guidance as far as how they interpret these propositions when it comes to property taxes. And so they're the ones who finally issued some, but they do it in the form of what they call letters to assessors. And they publish these, and they gave some initial guidance right after Prop 19 kind of came into play, but in the last 30 days, they gave some more. So let's just talk a little bit about Prop 19 and what it does, and then how is the Board of Equalization going to interpret this. So again, this is intended as informational purpose today. This is not legal advice, so don't take it as legal advice. If you want actual legal advice, consult an attorney directly. This satisfies my ethical obligations, so let's move on. All right, what are we going to talk about today? So Prop 19, how's it being implemented? How's the Board of Equalization, or BOE, looking at the various components of this? So remember what we talked about at the end of January, before Prop 19 was really coming into play, was I called the good part and the bad part. So the good part is the component of Prop 19 that allowed, if you're 15 or 55 and over, victim of a wildfire, victim or disabled or some other natural disaster, you could move transfer your primary residence tax basis to a new primary residence. Prior to Prop 19, this is going to be done in about 10 counties, but now it's all statewide. So this is the good part. And so there's some important guidance that are issued for this part as well. The bad part was that intergenerational transfer that they severely restricted. So I think the easiest way to go through this today is look at some of the examples that BOE actually put forth. So let's talk about the good part. Again, this was the part that if you're 55 or older, disabled, or victims of wildfire, you could sell your primary residence and basically transfer your property tax bill to a new primary residence. This is statewide. If you buy something that's equal or less than your original primary residence, this is good. It just transfers over directly. If you buy up, meaning you buy a property that's worth more than your original primary residence, then there's some additional property taxes that are going to happen. I have some examples that are going to illustrate this, so we'll get to that. The one key thing was this statute was effective April 1st. And there was I'm going to get to another example that's very key on this part, because the way BOE looked at this was a little bit different than we thought. And you have to move into your new primary residence within 2 years. So what the Board of Equalization did is they proposed what they call a property tax rule. This is not in place yet. All the property tax rules that I'm talking about today are proposed at this stage. They're open for public comment until mid-April. Then they look at all the comments. They may tweak the property tax rule a little bit, but more often than not, they don't. But they have to give the public an opportunity to comment on these proposed rules. So this proposed rule, this is the good part I'm talking about, is 462.540. They issued this out in letters to assessors. I'm giving you these numbers in case you ever want to look this up. I'm going to have a link to a Board of Equalization website, and I'll put it after into the chat as well. That gives you all these letters to assessors in one website. There's links there, so it's easy to access them. And the good thing about these letters to assessors is they're worded in ways that are pretty easy to digest. It's not really a lot of legalese. They do a lot of the examples that we use today. So for the good part, what they say is, if you sell your original primary residence, within 2 years, you have to either purchase a new primary residence or build a new home. If you do so, then you can transfer your property tax bill basis from your old property to your new one. This is the part that kind of got us caught off guard a little bit. It says either the sale of the original primary residence or the purchase or new construction of the replacement primary residence, but not both, may occur before April 1st, 2021. One of our big questions we had with this April 1st effective date was, can I sell my primary residence, let's say in February, and purchase a new property in March, but I still qualify under this new Prop 19? We had thought, as long as you don't apply for this, you don't claim this transfer exemption until April 1st, you're okay. But the BOE is coming down and saying, no, you can have either purchased your new primary residence before April 1st or sold your original primary residence before April 1st. You can't do both before April 1st. So there might have been some people out there who were relying on this Prop 19, sold their property in February, bought a new property in March. They're not going to qualify under this if this property tax rule goes through. I can imagine this component is going to get a lot of comment by the public and just other people in general. So we will see if this sticks, but I have a pretty good feeling this is going to stick. Now that we're past April 1st today, if somebody has sold their property or purchased a new one and they haven't closed on either their selling of their original primary residence or the purchase of a new primary residence until April now, they're going to be fine because one of those tests have been met. And they're going to be able to transfer their property tax bill from their old property to their new one. There's another key requirement here, and there's some examples I have to kind of illustrate this, but it says the original primary residence and the replacement primary property must undergo a 100% change in ownership. This term change in ownership is, in this world, it's a legal term. It has some meaning. So I think the best way to look at this is, let's look at some of the examples on how the BOE is looking at this good part of Prop 19. Example 1, a brother and a sister are co-owners in a primary residence. The sister sells her 50% interest to her brother, and she goes and purchases a separate residence then. Common scenario, brother and sister inherit property from their parents equally. One of them eventually sells to the other to go purchase their own property. Even if the sister is otherwise qualified, she's ineligible for this part of Prop 19 because the original residence that she owned with her brother did not go through a 100% change in ownership. There was only a 50% change in ownership because she sold her 50% interest to her brother. Therefore, she cannot transfer her property tax basis from this property to her new primary residence. This is an illustration of how we can get caught off guard about this change in ownership requirement. They want to basically be able to reassess the original property. They want that 100% change in ownership in it. This is the county wanting their money as far as property taxes. Let's look at a different example. Owner, one person, sells their original primary residence for $515,000. Then owner goes and buys a new replacement primary residence with 2 other people. They buy it for $500,000. This is actually going to be okay and eligible under Prop 19 because as long as the owner, because he sold 100% of his original primary residence, that means there's a change in ownership in that original primary residence. He gets to transfer his Prop 19 tax basis into the new property. It does not matter that there are 2 additional co-owners in this new property. So even though the original owner has now a 1/3 interest maybe in the new property, the BOE is saying this still complies with Prop 19. So this could be a good planning tool, maybe for individuals who are going to purchase, some other primary residence with maybe a new spouse or maybe with their kids, something like that, because we can still exempt that transfer under this new Prop 19. So I think that was pretty interesting that the DOE came down with this, because they could have went the other way. They could have just made this a pro rata or proportionate exemption. But they said, no, as long as one person complies or is eligible under Prop 19, we're going to allow the transfer to happen. All right, so example 3. Owner is sole owner of a primary residence, again, just like we had in the last example. This one has a market value of $500,000. The co-owner, which means a new co-owner, purchases a 50% interest in that same property for $250,000. The co-owner who's coming in sold their other original primary residence for $200,000 and met all their other requirements. But the co-owner may not transfer their value to original owner's residence because their 50% interest in the owner's primary residence did not undergo a 100% change in ownership. So this is illustrating that they want it to be a change in ownership on both sides. So we have a property owned by person A.
She told me she was.
Good.
I said, can you bring them by?
Bring them on by, I'll talk to them too. We have original owner owning property A, sells basically 50% to a new person, right?
But he's asleep.
Because it's only a 50% interest, it's not 100%. We don't have that change of ownership component. So that's why they're saying this is an ineligible transfer. So this is a good thing to know, especially in like planning. There's a lot, especially intergenerational or family planning. We're trying to decide who to put on title and who not to. You should look at this change in ownership component very carefully, because the county is going to be looking at these very carefully to make sure that they at least get a 100% change in ownership either on the relinquished primary residence or the replacement primary residence coming in. All right, this one is a pretty interesting one because I've had a lot of questions about, well, a couple of questions in the last couple of weeks actually. They say, what about divorcing spouses? We have spouses who are divorcing and they're going to go each buy their own new primary residence. They're going to sell their property they own jointly. Can they both transfer their property tax basis to their new homes under Prop 19? Interestingly enough, the BOE did not issue a specific example on that one. So we have to do some lawyering and analysis to try to extrapolate what the BOE is saying in other examples and guidance to be able to apply to that particular situation. And I actually think this one right here, this example is a good one. So you have a husband and wife who own a residence together as community property, jointly owned. The husband, remember under Prop 19, we back up, Prop 19, you can now do this 3 times. Each person can do this 3 times, meaning you can transfer your property tax basis to a new residence 3 times total, which is an increase from the old law. The old law said you can only do this 1 time. So in this example, husband has already done this 3 times. Wife has never done this. Maybe this is a second or third marriage and husband's done this several times in the past, but what we have today is they own this property together and it's their own residence. They sell it. Then they go buy a new property together again to a new primary residence. But because wife has not used any of her Prop 19 exemptions yet, she gets to use it. And she gets to exempt the whole thing. So they're not making a distinction between husband and wife and saying, oh, it's like shared jointly between them. They're saying, no, as long as one person qualifies under Prop 19, then it's going to qualify, the transfer qualifies. So this means that when husband and wife in this example buy their new primary residence, wife is the one who's going to claim the exemption. And she's going to say, my property tax basis and the property that we sold is going to transfer over to this new property. Even though my husband's already used all his up, it still applies for wife, so it's going to apply to the whole property. I think this is also going to, you can extrapolate this example into that divorce scenario, where husband and wife are divorcing, going their separate ways to buy their own primary residences after the divorce or incident to the divorce. If husband has the exemption available, he's going to be able to transfer his property tax basis to the new property. If wife has an exemption available, meaning they haven't used 3 of them yet, she's going to be able to transfer to her new primary residence. Even though we don't have a specific guidance, particularly on that point, I think this example applies, which is pretty interesting. That the BOE is being, they're kind of giving and taking on some of this, how they looked at Prop 19. There's some good guidance that came down. I think this is one of them. And there's some other ones that maybe weren't necessarily good, meaning that that strict change of ownership mechanism, I don't think was anticipated. But that's what you get when you talk with the BOE. They're kind of a wild west when it comes to government agencies in California. All right, so let's talk a little bit about the valuation component. It's pretty simple. It basically says, if the replacement property's value is greater than the full cash value of the original property, the property that was sold, then the basis of the replacement property is the difference between the full cash value of the replacement property and the full cash value of the original. I have an example to show this because that's not as confusing. What if the replacement property is equal to or less than what their original property was? Well, then they just transfer over the basis from the original property over to the new one and you're done, pretty easy. So let's look at that first one as far as an example. And when I say property tax basis, it's technically called the factored base year value. All these terms mean the same thing. It's just called, I like property tax basis because I think that's what most people understand. So the factored base year value or property tax basis of the owner's original primary residence was $300,000. So their property tax bills were based on that $300,000 value. The owner sells their primary residence for $550,000. Then the owner goes and buys a replacement primary residence for $500,000. So it's a little bit less than their original property was. Since the full cash value of the owner's replacement property residence, $500,000 is less than the original property at $550,000, we just transfer the base year value over, that $300,000 transfers over. In the next example, this is the one where it's going to be higher. Same scenario. The owner's original residence is $300,000 as far as their property tax basis is concerned. They sell it for $550,000, same as the previous example. But they go and buy a new property that's worth $600,000. So they bought up a little bit. Since the full cash value of their replacement property, the $600,000, is greater than the $550,000 that their original property was, that $50,000 difference gets added to their original factored base year value of their original property tax basis. So now moving forward, they have their full $300,000 property tax basis transferred over, but we have to add in that difference to it. So that's why it gets to $350,000. So there is going to be an increase in property taxes for them, and it accounts for the fact that they bought up. So in a similar situation, let's say you buy up $100,000. Well, we take that $100,000 difference and we're going to add it to your original property tax basis because you bought up. And the county's or the BOE is basically saying, if you transfer over to the same price or lower, you can pay the same property tax bill. But because you're buying up, you have to account for that increase, and we want more property taxes for that. We're just not going to let you go buy a $2 million property and pay the same property tax bill that you were on a property that was worth $500,000. We want to be able to give taxes for that difference. So this is the mechanism of how it's going to work. All right, so that was the good part, and I'm gonna have time for questions at the end of this. Good part's fairly straightforward, other than that change in ownership component. But for most people who are going to sell their primary residence, go buy a new one, that's probably the only transaction they may do for the rest of their life. It's pretty simple to them. They'll transfer it over, they file a claim form, it's done. Okay, and they can do it up to 3 times, no problem. Most people do go, they don't necessarily buy up, they usually go down. Like if you get into retirement, older age, you don't want the larger house, they may transition to a smaller, property, maybe it's a condo or something like that. So they're going to pay the same property tax bill. In the scenarios where they're going to buy up, they're just going to pay a little bit more. But again, most people are probably going to do this on average about 1 time. That's what the statistics actually show under this proposition. They did some analysis and they said most people do it about 1 time. So that's the good part of Prop 19. That's the part that they sold Prop 19 on, right? That's the part you saw the commercials for and how they marketed it. It was this other part, what I call the bad part. This is the part that caught people off guard. So what Prop 19 also did was it substantially limited the parent-to-child transfer exemption. If you recall, prior to Prop 19 coming into place, we had Prop 58. Prop 58 was that what it provided, parents could transfer property to their children, and there was an exemption on property tax reappraisal for reassessment, as long as it went parent to child. If it was a parent's primary residence, it was an unlimited exemption. We didn't care how much property is worth. And they had additional properties like rentals, commercial property, vacation homes. They could transfer a certain amount of those as well. Prop 19 did away with a lot of them. And the only exemption that's going to be available under Prop 19, as far as parent-child transfers are concerned, is the parent's primary residence. That's it. So anything other than a primary residence, those vacation homes, rentals, commercials, there's no more exemption for those. This became effective February 16th of this year. This was the big rush that I was doing and so many other attorneys were doing, transferring properties between parents and children in January and beginning of February. So this has been in place now for about almost 2 months now. And so it's funny because this part came in February 16th, but the guidance didn't come in until afterwards, of course, because that's the DOD report. So they did some interesting things on this one too. Basically what Prop 19, as far as this is concerned, says parents can transfer only their primary residence to their children. The child, at least one of the child, one of the children has to make that home their own primary residence within a year. And we're going to limit the exemption to $1 million above the parent's assessed value. So if the parent's assessed value is $300,000 in that primary residence, then the exemption is going to be topped out at 1.3 million. So if the property is worth more than that when it's transferred, a portion of that gets reassessed. Again, let's look through some of the examples. So what the BOE did here is they issued, again, a proposed property tax rule, but they did another piece of guidance I'm going to pull from too here in a minute. They issued out a letter that had a bunch of questions and answers, because I know a lot of people had questions about this parent-child part. So Prop 19 they expanded it a little bit through the guidance to say it's not just primary residences from parents, it's also going to include family farms. So, okay, because there was definitely people questioning about like how are we going to deal with farms that are transferring? There's always been some policy objectives to try to help those transfers, or at least down generations. So they included the family farms inside this component. So they say change of ownership shall not include transfer of primary residence or the family farm if the conditions are met. So we'll talk about the conditions, which I basically already touched upon. They must become the principal residence or, again, the family farm. At least one eligible transferee has to be able to qualify for this within 1 year of the transfer. The eligible transferee must claim either the homeowner's exemption, the disabled veterans exemption, either at the time of the transfer or within that 1 year period. If it's a family farm, they don't need to claim such an exemption because it doesn't apply to that. You still have to tell them it's a family farm. The claim form must be filed within 3 years. So it's kind of confusing. We're talking about a 1 year period as far as when they have to make it their residence or claim this exemption. But the actual Prop 19 claim form, which they are developing right now, that has to be filed with the county within 3 years. So there is a scenario that somebody doesn't file the Prop 19 claim form until 2 years down the road. Well, the county's like reassess some property taxes in the meantime. If that claim form comes in later on, they will go back and either refund those taxes, they said, the excess taxes, or they'll credit against the future property taxes. So it's not like you have to get the claim form in before the county reassesses, but that usually triggers people to say, oh, I should probably get that claim form in because the county's looking to reassess. But it doesn't always happen, especially after death. That's what I deal with a lot. We're filing claim forms 2.5 years later, trying to get the county to adjust their accounting, which is, as you can imagine, a little difficult sometimes. So the exemption, this is the part that I wouldn't say caught us off guard, but we did not think the BOE was going to go this route. Because a lot of the questions before this guidance was issued was, well, how long does a child have to live in the home as their own primary residence? A lot of us thought it was going to be like a minimum 2 year period, maybe as much as like 5 years. Well, the BOE came up with something different. They said the exemption can be kept only as so long as the eligible transferee maintains the primary resident, that is their primary residence or the family farm. So what does this mean? It says that once the child sells the property or moves out of it, the exemption is lost and they'll come in and reappraise it then. So how this could work out is parents could transfer their primary residence to their child. The child moves into the home, satisfies that condition of Prop 19. Child lives in the home as a primary residence for 10 years. But then child decides, I'm going to move out of this home, but I'm going to keep it and turn it into a rental. As soon as they move out of that home, and as soon as that property is no longer their primary residence, the exemption is lost. The county will come in and reassess the property. This could be 20 years down the road. It's just whenever that child no longer makes up the primary residence. So this is not a great guidance that came from the BOE. We didn't expect this. We didn't expect them to be able to track this for so long, which they claim that they will be able to. So again, we're going to find out. So that's, yeah, I wasn't too happy about that, but it is what it is at this point. Let's talk a little about the valuation, because this is that second main component of Prop 19 when it comes to parent-child transfers. We have the exemption is going to be limited to the parents' property tax basis plus $1 million. So quick example, parents factored base year value of the property tax basis is 250, which means the total exemption available is 1.25 million. That's the 250 plus the million. Pretty easy to see that. So let's go through some of these Q&As that came from one of the letters to the assessors to kind of illustrate some of these components. This is an interesting one too. It says, the rush was to get these things recorded by February 16th. That was the big rush. Well, what if it didn't get recorded in time? And that's what this question basically was. I have the deed signed, it's notarized, it's ready to be recorded, but it didn't get recorded before February 15th. Does that mean that, you know, we're under Prop 19? And the BOE said no, as long as the date of the transfer is on or before February 15th, the transfer will qualify for the old law, which was Prop 58. How this works legally is the transfer itself does not necessarily have to be recorded, right? Recording, let me back up. The data transfer is the recording, that's what they call a rebuttable presumption. So like the county presumes that the recording is the date of the transfer, but you can rebut that presumption with evidence. So they've even come out and said, if the deed was notarized before February 15th, that'll overcome that rebuttable presumption. And they'll say that that's when the transfer actually happened. Because transfers usually happen when the document's signed and delivered to the transferee. And then the transferee will go through the recording process. So as long as it's been signed, notarized prior to February 15th, and delivered to the transferee, the transfer has actually already happened legally. Recording is a mere formality at that point. So this has some people, this answers some questions out there of people saying, well, I didn't get recorded in time. Am I okay? Yes, you could be, as long as you had everything signed, sealed, and ready to be delivered before February 15th. But it also kind of raises some other issues of maybe some people saying, well, maybe I can still go back and try to do this. But if you notarize something today saying, oh, well, we actually transferred it back in January, but you notarize that today, it's probably not going to rebut that presumption. There's going to be some other evidence to document that you actually transferred the property prior to February 15th. So I've had some questions about this as well. I thought this was a pretty interesting position that the BOE took. Okay, because one of you might have a question about, well, how do they define family farm? The proposition defines family farm as any real property which is under cultivation or which is being used for pasture or grazing, and that is used to produce an agricultural commodity. So you can look to that section 51-201 of the government code, it's California government code, to define what agricultural commodity is. It's typically what most people think they are. So it's usually grazing, definitely cultivation will definitely fall into this, but it's a pretty broad definition. And so that, remember, family farms also can qualify as a parent-child transfer under Prop 19. Okay, so here's a question that was interesting too. People say, I'm planning to transfer my home to my 2 children. Must the property become the family home of both children? I had this question a lot before February 16th. Does that mean both kids have to live in the home? My original answer was, I don't think so, but we have to wait to see what the BOE was going to say. Well, now they're telling us, no, as long as one of the children are going to live in the home, that means we have at least one eligible transferee that will qualify the transaction for the exclusion. So that actually was pretty helpful that the BOE came down with this, because I thought it'd be kind of ridiculous if they required siblings to live together in this home. That just doesn't happen practically for the most part. So they recognized that, and they said, no, as long as we have one child who's going to live in the home, it's fine. So that was a good position they took. What about if you inherit your parents' family home, move into it, and establish it as your own home? How you have to live continuously in the home to receive this, exemption. I talked about this a little bit before, but this is actually the position that the BOE took in this letter. It says the exemption or the exclusion is going to apply as long as that eligible transferee is living in the home, claiming it as his or her primary residence. Once they move out, no longer qualifies, it will be reassessed. Or there's a different exemption that's available. This is a planning objective that I do a lot with my clients. We might have transfers from parents to children. then maybe from children to their own children, which is the original parent's grandchildren. So you can use these in successive steps where you can say parent to child, qualify for the exclusion, child lives in the home. Child lives in the home for 20 years, has this exemption available. Child says, I'm going to move out. But before they move out, they transfer it to their children. And at least one of their children moves into that home, right? It becomes a family home at this point. Then we have a second exemption to cover it. So this is good to know as far as that we can do this in successive steps as far as down the generational line to be able to qualify exemptions all along the way. But once this is nobody's primary residence, that's when it gets reassessed. So it's going to be very much down the road. I'm kind of surprised that DOE is going to put it on the counties to be able to track this for so long. We'll see if we can. So I moved back into the home I grew up in to live with my aging mother who needs care. Very common scenario. She wants to give me the house, on my next birthday, which is May, which is after the exemption. So after the effective date. So we're definitely in Prop 19. Current taxable value of the house, which is basically the property tax basis, is $200,000. So that means mother is carrying $200,000 as her property tax basis. When she transfers the property to the child, they have to pay a property tax change. And it says it depends, because this is that valuation. This highlights that valuation component. We have a couple different things we have to satisfy. One, the transfer is parent to child. Yes, clearly it is here, mother to child. Child's going to move in the home. Well, the child's already living in the home. So yes, we have that covered as well. Third step, what's the valuation limitation? Well, in this one, it says if mom's property tax basis is 200, we get $1 million on top of that. So a total exemption of 1.2 million. So at the time of transfer, what is the property worth? If it's worth 1.2 million or less, no changes to the property tax, because we have enough exemption to cover it. If the property is worth more than the 1.2 million, then the difference between the 1.2 million and the fair market value, in this example, it's 1.5, that $300,000 difference, that's the part that gets reassessed. So it will increase the property taxes, a little bit based on the $300,000 difference, which translates to about $3,000 change, increase in property taxes per year. So it's not enough to just look to parent to child and the child going to live in the home. We still have to bring in this valuation component as well to make sure we have enough exemption to cover it. Sorry. Okay. There's one other example I want to give you. I pulled this from a part of an example, just to kind of, I know it's a lot of numbers and math here, but it just kind of illustrates how it doesn't have to be an all or nothing proposition. A lot of times in planning that I do with clients, you might be transferring partial interest in the property. So there was a question that we had, well, how is the BOE going to treat partial interest that are transfers? What if there's only a 25% interest that's transferred to the child? Does that mean that the exemption gets proportional at that point? So the BOE came down and said, no, we're just going to look at a total exemption. So in this example, it just says, mother's family home is 600,000. Fair market value was 800,000. When the 25% interest was transferred to the child, fair market value was less than that total. So remember, we had a $600,000 property tax basis in this example, plus $1 million. So we have 1.6 million to work with as far as exemption. The 25% interest is much less than the 1.6 million. Actually, the whole property is worth less than 1.6 million because the fair market value was 800,000. So the BOE just says, as long as it's under that 1.6 million the property is, it doesn't matter if it's a portion of the property that's transferred or all of it. It's just, they're going to consider it completely exempted. But that sounds, okay, that makes sense, right? We're under the exemption, we're not worried about it. What if we're above the exemption? This is where they do get a little bit proportional in there. So let's say in the same example, mom's property tax basis was 600,000, but the property is worth 2 million, okay? Since the property tax basis was 600,000, we get to add $1 million, we're at 1.6 million again. but the property is worth 200 or 2 million. So we have a $400,000 difference. Then they're going to look at, and they're going to say, okay, the 25% of that $400,000 difference, or $100,000, will get added to the taxable value of the 25% interest. And that's a little bit confusing, but they're saying, then we're going to take the portion that's above. So to say, if it's $400,000 total, it's a 25% interest that's transferred. We're going to take that 100,000, which is 25% of the 400, and we're going to add it. So that's the part that's going to get reassessed in this scenario. That $100,000, which will increase property taxes by about $1,200 or so. So as long as we're under the exemption, the takeaway is, as long as we're under the exemption total, it's exempted. Doesn't matter if it's partial interest or 100% interest. But once we have a property that's worth more than the total exemption available, then we should look at carefully, what is the interest that we're transferring? Is it, if it's 100%, we know what the reassessment will be. If it's a partial interest, maybe it's 25% interest in this child, 25% interest in child B, we need to look at that because we got to see how much, and plan for how much the property tax increase is going to be. This is also going to be key because I guess I'm a skeptic when it comes to the county assessors getting this right every time. Sometimes when they send those reassessment notices out, I look at them very carefully with clients that I work with to make sure that they did the calculations correct. And guess what? Spoiler alert, they don't always do that. So you want to also check their work, make sure they're not reassessing more. Because sometimes they might look at that 400,000 to say, oh, property's worth 2 million. There's only 1.6 million of exemption. We should just reassess all 400,000. And say, no, we only transferred 50% of the property. So you shouldn't reassess all 400. At most, you're going to reassess the 200, half of it. So this is important to be able to track these numbers, these property tax basis and the values of the properties to make sure that county assessor, when the assessment does come in, that we're planning for is correct. So I hope that a lot of these examples kind of illustrated how the BOE is looking at Prop 19, how they're going to implement it. If you go to this link right here, which I'll also post in the chat when I'm done here, this has got all the links to all the various guidance that they've issued so far. And there's only about 5 different pieces of guidance they've issued. The examples I showed you today all come from a couple different ones for the most part. But again, if you want to go look and read it yourself, go to that link. This is me and my firm. I'm Ryan Lockhart. I'm the tax and estate planning attorney. We had some real estate attorneys and a business transactional attorney were in Walnut Creek for McKenna, Brooks, and Naradi. And give us a call if you have any questions, or we can help you out in any other ways, because we pretty much do everything, but we don't do divorce, family law, or bankruptcy, but most other things we can handle. Thank you very much, and I appreciate you listening to me today. I know there's some questions, so just give me 1 second. And I will stop sharing. Good. All right. Before I jump into the chat, does anybody have any comments or questions out from the get-go here?
What's the best way to apply?
So there's going to be a form that it's going to be a Prop 19 form. I saw a version of it, and it's a two-page form. So that's how you're going to do it. So once the transfer is completed, you're going to fill out this. Here's what I recommend. Let me back up. Here's what I recommend. When you do the transfer, you record the deeds, get that done, then send in this Prop 19 form to the county assessors separately. I have found in my career that it's easier to let the recordings happen because it filters from the recorder over to the assessor's office. Let them get that, then send the Prop 19 form directly to the assessor's office. So when they get your Prop 19 form, they can look at the recording data that they have, copies, and they can apply the exemption. Sometimes when people send the claim form in with the recording, it too often gets lost on its way to the assessor's office, and you have to do it again.
Thank you.
That's my recommendation.
I have some questions in the chat box too.
Okay. How long must a parent live in the primary residence if transferring to a child? There's actually no requirement on this. As long as the parents are claiming the homeowner's exemption or the disabled veterans exemption, that means they have put forward to the county that it is their primary residence. So you could literally buy a home. Mom and dad could buy the home, live in it for 30 days, get that homeowner's exemption into the assessor's office, turn around, transfer to the property. There's no requirement, no time requirement. The parents have to have lived in that primary residence.
So if a parent lived in the primary residence for many, many years, it was primary, then rented it out, as soon as it's turned into a rental, is that all?
It has to be the primary residence when they do the transfer to children.
Gotcha.
So the better idea is if it's a rental, get rid of your renters, move in for a month, and then transfer it and bring renters in again. If you
Gotcha.
wanted to do
Okay. I didn't hear that here, but thank you.
that.
And how about a husband and wife?
Good question.
Do they both have to be 55?
No, we just have to have one eligible person. So as long as one person is 55 or older, then the whole exemption is available.
Okay.
So you can have one spouse at 55, one spouse at 53. The spouse that's 55 is the one making the claim.
And the only other question I had, which is in the chat box, which is very small writing, is do you have an updated podcast?
I do not have one up yet, but I will. I think I'm slated to get an updated Prop 19 podcast out next week. So
Okay, thank you.
I'll have that out. Scott had a question that said, while this will hurt at transfer, what is going on with the step-up basis? Good question. Okay, yes, step-up basis. So we'll recap what the step-up in tax basis is. When you transfer property during your lifetime, your tax basis in the property, this is an income tax question, transfers with that asset. Instead of transferring during your lifetime, if you die holding that property, the tax code, internal federal tax code, allows a new tax basis to be established based on the value of the asset on your date of death. They call this a step-up in tax basis. What this effectively does is eliminates built-in unrealized capital gains. So this is I definitely use this in my planning all the time, where we want assets that mom and dad are going to hold during their lifetime. When it transfers to the children after mom and dad have died, we want to capture the step-up in tax basis. This is on the chopping block. Biden has already put forth out there that he would like to eliminate the step-up in tax basis if he can go that far. I don't know if he can go get that, but he would like to eliminate it. So there's definitely that same cost-benefit analysis. This is the analysis we were doing in January. What is better bang for the buck, right? As far as what's the bigger savings here? Transferring the property to children during your lifetime where you forego the step-up in tax basis, where you can lock in property tax savings in the Prop 19, presumably qualify. Or is the step-up in tax basis, which is a capital gains analysis, is that better for the children? Quite frankly, I would say about 75% of the people I talked to in January about this, the savings and the capital gains using the step-up in tax basis it outweighed the property tax savings. Basically, we did some analysis where it said it would take the children 20 years or more on the property tax savings to equal what the capital gains tax savings would be. So each case is different. This is an analysis that has to be applied individually, but I don't think he's going to be able to get rid of the step-up in tax basis. We will see what the proposal looks like. I still think this tax proposal is coming from them probably in the fall. But there's definitely a lot of lobby groups saying that the elimination of the step-up in tax basis is going like a step too far. And we'll see. If they get rid of it, then it's going to change all kinds of planning. One other thing I should follow is Prop 19 is definitely not, it's not loved right now. Let's just say that. There is a movement, and I know somebody who's in this movement, if the recall election gets on the ballot in November, there's a chance of that happening. They said they've already almost got enough signatures to get Proposition 19 back on the ballot in November if there's going to be a recall election. So there's very likely, not very likely, there's a chance that this Prop 19 could get either tweaked substantially or just tossed out. I'm talking about the bad part, the parent-child component. Tossing out that component maybe even as soon as November. If not November, they're definitely moving forward to the next general election, which would be, just shy of 2 years now. We're talking 2020. 2023, 2022. So I don't know how long Prop 19 is going to stick around the way it is today. It just got in, but people are not happy with it. They feel like they got kind of blindsided by the parent-child component. The other good part, most people agree with that, so I don't think that's going to go anywhere. But this parent-child one, stay tuned to see if it gets straight up eliminated or tweaked to a certain degree. I put the link to that BOE website in the chat, and that's what I got for you today.
Cool. Is there any other questions? Yeah,
James.
I do have a question. If when Prop, what was it, 65, whatever the other one, before, where the parent can transfer to a child,
Prop 58.
when that was already filed in the past, does that change?
No, so Prop 19 only is from February 16, 2021 going forward.
Okay.
Any Prop 58 transfers you did in the past are done, sealed, delivered.
And then if a property is a concurrent close, that's not a problem, as long as it's after April 1st.
Correct.
Okay. Thank you.
Go ahead, James.
No worries. I'm a director at CAR, right? And so a lot of us who are more young on the board of directors, we're very vocal about this elimination of the parent-child transfer. We warned them it was going to be an issue and they didn't listen to us. But my question to you is, if this does go back on the ballot and there's some kind of significant change or repeal of it, those people who have already taken advantage of it, I assume, would be allowed to keep that, or is there a chance that it could be repealed and they would lose that later?
I think if it's repealed, they're going to build in language that will make it better for people who took advantage of Prop 19 to make it even easier. I think they want to go back to what Prop 58 was. That's what I'm hearing from it. The gentleman that I know was a part of the lobbying group that got the good part of Prop 19 on there. And he said the bad part got added on later and they don't know who really put it on there. So they want to get that part eliminated, at least go back to what Prop 58 is at a minimum. Well, actually, I shouldn't say at a minimum. That's where they want to go, but I was talking to him, he's like, they may have to concede that they'll keep Prop 19 to some degree, but at least take that exemption limitation, the valuation limitation, and at a minimum remove that, so that you can still get that unlimited parent-to-child transfer of a primary residence.
All right, yeah, and when we fought this, what they told us was that the legislator told them they were going to take it anyways in a few years, so we should just give it up now to pass Prop 19 now, but that it was on the chopping block in a few years anyways. So it's going to be very interesting to see if they can push it back and reinstate it, because what they told us was it was in 2024, it was already going to be on the next chopping block anyway. So,
well, they got some good feedback then, didn't they, on this Prop 19 side?
They did, absolutely. And like I said, the younger people got told that we were greedy. And of course, it was by those who'd already gotten their exemption already and were enjoying that. So it was quite a vocal issue there. But thank you for your talk today. I really appreciate the information.
I got a quick question. Wasn't the quote unquote bad part wasn't that inserted in there because the first time Prop 19, when I don't know what it was called the first time around, when it got voted down, didn't they have to put in that aspect of it to satisfy some of the special interests and whatnot that were concerned about the revenue stream? Wasn't that kind of a, okay, we'll give you
that's the talk. I mean, that's I've heard that as well. But interesting to me, because I know people who were deep in this, and they were like, that is unofficial. I think that's what probably happened, but they're not. They haven't been able to confirm that's exactly the reason. They felt like if that was a reason, that it was a revenue component for budget purposes, et cetera, they said they should have came forth with that, but that didn't happen. So there's been a little bit of a questioning and kind of finger pointing back and forth across various groups of who's really responsible for the second part of Prop 19. And it seems like because I think the backlash has been so pretty harsh right now, that they're even doing more finger pointing, like, oh, it wasn't us.
Yeah, I remember the CAR person that came around kind of pitching the Prop 19. He was basically saying he called it the Lloyd Bridges thing, right? Where James is nodding, where he was saying, this is how we managed to sell it this time, was by putting this in, because we're taking away that quote unquote loophole for the wealthy people is how they did it. And that's, he came right out and said that that was there to satisfy the opposition the first time around. So whatever it's worth.
And for whatever it's worth, I'll just give you anecdotal evidence from my practice. Prop 58 was a heavy part of my practice in estate planning. And it was almost entirely, not almost entirely, because I do work with a lot of wealthy people. But for the non-wealthy people, and I say wealthy in my world, it's like 15 million or up, it was transferring their primary residence to their kids, because that's the only property they owned. And so to put the limitation of $1 million above on that, yeah, that might work in parts of the state where property hasn't gone up more than $1 million in 20 years. But around here, that's not happening, not for everybody. So it's definitely catching. I think it's the net is too wide. If they want to like sell it, say like, well, let's tweak that exemption top out of $1 million more. I think that could go a long way to, if that's the position they want to take. All right.
Any other questions? Okay, well, thank you, Ryan, so much for coming back and explaining
My pleasure.
guidance for us. And I'm sure we'll have you back again.
Anytime. This is fun. I like your group. It's fun.
Thank you, Ryan. Always appreciate the help.
And thank you
My
for
pleasure.
attending.
Thanks, Ryan. We will have the recording available on the next news views as well. Ryan, do you have the slides available?
I will send them to you.
Okay, awesome. Thank you.
All right, well, thank you, everyone. And as always, thank you, Jean, and thank you, Tanya.
Thank you, Ro.
Thank you, Ro.
Bye, have a good day,
Thank you,
everybody.
Ryan.
Have a good day.
Take care, everybody.
All right, thank you. Bye-bye.
Thanks for everyone
Ryan,
for
thank you
coming.
very much.
Yes, that's it.
That's it. Okay, you're gonna,
I'm gonna end it now. Oh.
yeah,
we
okay.
did.
Oh, let me hit